An emerging area of law and statutes, and really we're just getting started. But the questions that this law seeks to answer is what rights do consumers have? I should say, by the way, that businesses are consumers too, and nonprofits and governments are consumers too. We buy goods and services. But this is a question about what rights individuals and entities have when their data is collected and what recourse they have. So why is this an important question? If you take a step back, the tech boom and the development of social media and the big technology companies and these devices has dramatically transformed our lives in many positive ways. But it's incredibly disruptive, number one, to our lives, to industry, to the way we do things, to the way we learn, to the way we conduct government. And I would say that in this country, we jumped on the tech bandwagon because of the boom and because there's been a gold rush in technology. And I think sometimes we have failed to stop to consider all the issues that come with this new age, this information age, the democratization of information. And what has developed in America, I think by many experts' reckoning, is what has been often referred to as the surveillance economy, right? And I think all of us, if you're honest with yourself, that's a fairly apt and descriptive term to describe the economy that we all live in and benefit from and operate in and buy goods and services from, and sometimes are prejudiced by. Because now we have a system where many companies surveil all of us and what our preferences are, what we like to buy, where we shop, in what quantity, how much money, and all of this information is sloshing around, not just in the internet, but in the hands of public and private actors. And because of this gold rush, and because we have moved towards this surveillance economy, in America, we have tended to treat our personal information as a commodity, as something that's bought and sold, right? And that is used in trade or commerce. The Europeans took a different approach. And the Europeans have a set of laws known as the GDPR. And in the GDPR, there tends to be more of a focus on personal data as a property, as a piece of property, a property right, as personal property. And the Europeans, in their approach, have tended to focus more on individual rights, on opting in, opting out, on providing notice and disclosure. So, how many people have been to Europe in the EU in the past year or two? Okay, so I went to Spain last year, and I tried to get on ESPN.com and CNN.com, and not the Spanish version. I want to see the US version. But every time you go to a website on any device, there's a disclosure page, and very often an opt-in page. And that's because of the GDPR's strong protections. Interestingly, when you hear from US tech companies that they can't do all of that because it's too expensive and too cumbersome and it's too demanding, the response should be, but you do it already in Europe, so you can deploy that technology here. California and its CCPA was the first in 2018. I think when people think about data privacy, cybersecurity, they think about personal property rights, they go first to California, because California was the first mover, by the reckoning of some people in the tech industry, too draconian a move. I think many of us who are trying to protect consumers think that California was headed in the right direction. They have a lot of things to iron out. But because of California's experience, we were able to learn, and many other states like Virginia, our sister state, which acted roughly at the same time, we were able to learn from California and its experience And so we developed in the state legislature what is now the fifth state to pass a set of laws known as the Connecticut Data Privacy Act. So you see the list of states. It's interesting. It's a mix of blue and red states, of coastal and rural and Mountain West states. So what that should tell you is that everyone is reckoning with these issues and frankly racing to address these issues because consumers and constituents want answers to what their rights are. And so with that, I'm going to turn over to Michelle, and she's going to go through the specific provisions of the Consumer Data Privacy Act in Connecticut and the new rights that it creates for consumers here in Connecticut.
Right, well, thank you very much for having me. So again, my name is Michelle Buchanan. I head up our privacy section in our office. And as the Attorney General said, we are really unique in the fact that we have a dedicated privacy section. Not all AG offices do. And we were the first to do so. And I feel really lucky for that because privacy and data security is such a complex area. You really need to be able to focus on it full time to make a difference. And so we're able to do that with our team in Connecticut thanks to the Attorney General and our office. And so the AG already went through some of our noteworthy cases, our enforcement cases in the past. And our team has been very busy working on these cases since the inception of our section in 2015 and even before that. But we are getting ready to enforce this consumer data privacy law right now. We've been doing a lot of work over the past year to make sure that we are prepared, that we are trained, we're educated on these issues so that we can take a fair approach to enforcing this law. We only have a few weeks. Actually, I think a colleague of mine in a meeting yesterday mentioned to me that it was 9 business days yesterday, which made me panic a little bit, but we're ready. And I thought I would give you today a little sense of what this law requires, who's covered by the law, and we can also share how we're thinking about this law, and also wanted to provide some tips for businesses that are trying to take steps to come into compliance with the law. So that's what I'm going to do today, starting with who does the law cover. There's a threshold for application in the law, and it hinges on how much personal data is being collected. I've done a few of these events now. Sometimes I'll get questions, am I covered by this law? And my answer is, I don't know. You know that based on the amount of information you're collecting. And here's the threshold. This threshold is similar to the thresholds in other states. The idea is to capture entities that are controlling a significant amount of our personal data. There are a lot of exemptions in the law, unfortunately. Here's a list. I heard nonprofits mentioned before. Nonprofits are exempt from this law, but the Attorney General mentioned other really important privacy and data security laws in Connecticut that nonprofits are not exempt from, so this doesn't mean you don't need to listen to the rest of my presentation. And also, states are approaching this differently. So nonprofits are exempt in Connecticut, but they are not exempt in Colorado. And I think that is a trend we will continue to see. So this is relevant. But there are both entity level exemptions in the law and information level exemptions. And so for a more comprehensive list, take a look at the statute with the nuance being not all entities and information is covered under the law, but we're trying to capture the entities and information that makes sense to apply consumer data rights to. And for some of these entities, the thought process was there's other regimes that those entities already have to comply with, like the GLBA or like HIPAA, and we wanted to recognize that. But the main takeaway is these rights and responsibilities also shouldn't be ignored, because a lot of the foundation of these rights and responsibility already existed through the other statutes that the Attorney General mentioned. Okay, so what are the consumer data rights that we all have as Connecticut residents under the law? We have the right to access the information that a company is holding on our behalf. We have the right to ask that any inaccurate data be corrected. We have the right to request deletion of our personal data that we don't want a company to have about us. And then importantly, we also have the right to opt out of the processing of our information for targeted advertising, sale, and profiling. A few nuances here worth mentioning for Connecticut's law is that the deletion right applies not only to data that a company collects directly from you, but any data that a company has obtained on your behalf. And one reason that's really important is data brokers and the amount of information that data brokers collect on us. I've seen these spreadsheets. There's fields and fields and fields of information, and it's pretty mind-blowing the types of profiles that can be created about you. Sale is another thing I wanted to highlight really quick. Sale does not mean the traditional definition of sale. It's not buying something. It's not the exchange of data for money only. It's the exchange of data for any type of consideration, because if it was for money only, it just would not reflect how this modern marketplace works with respect to consumer data. And then lastly, another thing to point out is that there's two important areas in the law. One saying that consumers can designate an authorized agent to exercise these rights, and another requiring entities to recognize global opt-out signals. And the thought process there is, it would be a full-time job for us to really effectuate these rights, just considering how many companies collect and maintain our data. So there's these provisions in the law to hopefully offset that burden for consumers and make it easier for all of us to effectuate these data rights. Business obligations. So very important slide. These are all of the obligations that apply to controllers, which are defined as entities that determine why and when your data is collected and processed. The obligations that attach are the duty to minimize data, so to collect only what is necessary for your business. The duty to be transparent about what information you're collecting, why, how long you keep it for, who you're sharing it with, why you're sharing it with other companies. There's a lot of requirements for disclosures that need to be added to privacy policies come July 1st. Purpose limitation: if you're collecting data and you're telling someone that you're collecting it for a certain reason, you need to stick to that representation and limit the use of that data to that purpose. Reasonable data security: this is a requirement that's already existed in Connecticut law, but this solidifies that responsibility. If you're collecting information, you need to have data security measures in place to protect that information. A key part of Connecticut's law, which actually is unique from California's and built on California's model, is that our law requires companies to get our consent to process sensitive data. What do I mean by sensitive data? There's a long definition in the law, but it includes things like biometric data and location information. So it's this heightened protection for these more sensitive data elements. There's also heightened protections for teens data. The AG talked earlier about how important this is right now, how vulnerable our kids and teens are to privacy harm. So this is a component in the law geared towards addressing that and to give teens more protection over their privacy. And then the law requires that companies do not discriminate against consumers that effectuate data rights or process data in a way that would result in discrimination. And then finally, the law requires companies to conduct data protection assessments, which are basically assessments of what could the impact be of this information collection and processing based on the data you're collecting. So this steps up for the more sensitive information a company collects. Okay, so those were the responsibilities for controllers. Now I'm moving on to processors, which are entities that do the actual data processing on a controller's behalf. And there's responsibilities for those entities in the law as well, including that they have to follow a controller's instructions with respect to consumer data rights, because it would be pretty unfortunate if our rights didn't carry down the line. everyone's using third parties, everyone's using vendors, and if we could only go to the direct entity we're dealing with for consumer data rights, these rights would be empty. The data would have been passed along, it'd already be out there, and we really wouldn't be doing much of anything. So there's provisions in the law that require these rights to be passed down the chain. And there are detailed provisions about contracts that need to be in place between these entities to make sure that boundaries are set, data security requirements are passed along. Okay, so enforcement. I said I wanted to share more information about how our office is thinking about enforcement, and to do that I wanted to just share very quickly what the enforcement structure is like. Our office, the Attorney General, has exclusive enforcement authority under the law. There is no private right of action. So this will be a big responsibility for our office that we're ready to take on. The Attorney General mentioned up front that a lot of our past privacy work was grounded in our Unfair and Deceptive Trade Practices Act, and because of that, violations of our Consumer Data Privacy Law will be violations of our Unfair and Deceptive Trade Practices Act. This helps us, we're used to that structure. It's a good structure for dealing with violations because it allows us to seek not just penalties for violations, but also injunctive relief so that we can make sure that those violations don't continue. And then just a note about the penalties that are available under our CUPA, which is up to $5,000 per willful violation. Another thing that is interesting for this Consumer Data Privacy Act is that there's a cure period in the law, which we're not used to. We don't have this in other statutes that we enforce, but basically what it requires is after July 1st, if we become aware of a potential violation, we need to reach out to the business and let them know that we think this is a violation of the law, and the law gives that entity 60 days to come into compliance. This is something that is very much built into our practices already. So even before this law takes effect, for how we normally do things is if we get a consumer complaint, we read a news article that raises red flags, we will very often reach out to a company and say, we're concerned about this, tell us your side of things. That's just what we do. So this reflects that, but the important language in the statute is if the Attorney General determines that a cure is possible. That's really important. This is a very multifaceted law. There are certain violations that I don't know how you cure them, especially in 60 days, and so this will be something that we will have to take a balanced approach to, thinking about what the violation is. An example, a consumer data rights request. If you ask that your data be deleted and a company doesn't honor that, that is something that we could reach out to the company and hopefully they will fix. If they don't and we see a pattern, then we need to be able to pursue that pretty quickly. Okay, and then after this cure period sunsets, or it phases out after January 2025, and then we can provide a cure period if we determine it's appropriate. Enforcement report. So when we come to these events, this is a new law, I know, and a lot of there's a little bit of anxiety about new laws, and there's always this request that we be transparent about our work, which is something we do very regularly. We issue press releases about our investigations and our settlement agreements. And this is another unique component of this law because we are statutorily mandated to issue a report next year after our first year of enforcement to let Connecticut businesses know how many cure notices did we send out, what violations were fixed, and it also says any other matter we deem relevant. So this could be a good tool for us to get the word out about what we are seeing for violations and what our compliance expectations are. But it is really unique because we've never had to do this. We're mandated by statute, but we do a lot of this anyway. And okay, so tips for preparing for compliance. I think for entities looking at this July 1st, hopefully a lot of this are things that you're already doing. But the first step is to determine, does this law apply to you? Think about what information you're collecting, how sensitive is that information, look at the entity and information level exceptions and figure out what do you need to be doing to come into compliance. Inventory data, I can't stress enough, is just knowing what information is coming in, where is it held, who has access to it. This is a learning experience we've had through our data breach investigations, is how many companies just don't even know what information they have or where it is. It's pretty shocking, actually. Minimizing data, if I could stress just one step, it would be this, is really take a hard look at what you're collecting, and do you even need that information? Okay, so we've seen data breaches of highly sensitive information like social security numbers, and we've reached back out to companies to say, why were you collecting these social security numbers, and gotten no good response. And if the social security numbers had not been collected in the first place, this company would have lowered their risk for a data breach, maybe not even had any data breach notice reporting obligations, and it would never have led to an investigation by our office. So it's just a small takeaway, but just like I said with data inventories and the learning experience that many companies don't know what information they have, we've also seen that a lot of companies are collecting a whole lot of data that they don't actually need. Reviewing and updating privacy policy, as I mentioned, the required disclosures, and then operationalizing consumer rights is a big one, because this is a takeaway from California's first year of enforcement, where they found a lot of companies that had links in place for consumers to effectuate data rights that did not actually work. So just make sure those links are working. Reviewing and updating vendor contracts, and then last but definitely not least with employee training. That's everything in privacy and data security world, is you can have the best policies on paper, but if you're not training your workforce to recognize those responsibilities, those policies will be empty. Okay, and then last, I just included a resources page for anyone hoping to gain more information before July 1st. We put up an FAQ page on our website about the Connecticut Data Privacy Act. We do it as a baseline. It walks through the law, hopefully explains it in an easy to understand manner. But we plan to continue updating that. So if we're getting a lot of questions about the law, we'll add to this FAQ page on our website. So keep this in mind, take a look at it. Let us know if there's anything that's not clear, any areas that we can build on. We're happy to take a look. And then I've included resources from California's regulation process, Colorado's regulation process, and some examples of enforcement cases coming out of other states. We coordinate a lot with our sister states, so for anyone looking for more information about how we might approach a certain issue, looking to how other states have done so will always be instructive for us. We'd be very hard pressed to take a position that is different than one of our partner states, and we frequently collaborate on privacy cases because these issues don't stop at state borders. But I think that is it for me. I know there was a...
Well, we'll take some questions, but I thought I would just sum up with a couple of quick thoughts. There was a slide that I didn't address, the first slide for this section, where we said everything old is new again. And the reason why we said that is although there are a lot of new concepts here, a lot of new rights, the way we're approaching it feels a lot like the way we've done it for a long time. And so this codifies a lot of practice that's out there already. And as we said the last time when we were here, if you have questions, if you have an issue, while we can't give you legal advice, and you know better than we do whether you're covered by the law, if you have a concern, if you have a data breach, if you're not sure what your obligations are to respond to a set of consumers or an individual consumer, customer, if you feel like you violated the law, maybe, if you're not sure, call us, okay? And Michelle has always, in our section, has always taken a collaborative approach. I know that's hard for people to do, to call law enforcement and say, hey, I may have a problem. But I assure you, that's the best way to head off a problem, is basically to come in, hands open, and say, look, things happen. We're a small company, we're based here in Hamden or New Haven, and we're not Google, and we need your help in working through it, and our job is to work through it with you. Obviously, if we see something that is a gross violation of the law, and you didn't take the steps you need to take, you're gonna be held accountable. But that doesn't mean that we won't try to work through it with you in the first instance. The second thing I would say is, every time I go through this presentation or presentations like it, it's a reminder to me how I experience this as a consumer. How often we go into an office or buy a product or fill out an application where they collect way too much information, right? Why do you need all that information? You do it because you want the product or the service, or you want your doctor to see you, or whatever it is. But for those of you that have a set form that you've just been copying, or that is online that you developed 5 years ago, and you just ask your customers to fill it out, go back and review that form. You don't need social security numbers, right? There's a lot of information that you don't need, and I would encourage you to sharpen your pencils and collect only the information that you require to provide the good or services that you're providing. There are a bunch of exemptions. This is the vagary of the legislative process. I won't question the wisdom of the legislature today on all the exemptions and on the third period, which we love. But what I would say is be careful, and I would err on the side of compliance, right? Don't get right up to the line and say, well, I don't really count. You know, if you're playing at the margins, you put yourself at risk. So I would err on the side of compliance. You may think that you're a nonprofit and you're not subject to this, but there may be aspects of your service that take you out of the exemption, particularly if you partner in a public-private partnership of some kind. So I would just be careful and err on the side of compliance. The final thing I would say is this affects all of us. So on my desk in the Office of the Attorney General, amongst all the papers on all the cases and investigations we're doing, is a stack of fake credit card applications and disputes that the Attorney General of the state of Connecticut, had to personally spend time doing because somebody has been trying to open credit cards under my name with Bank of America. There's like 5 or 6 of them, okay? And for anybody here who has dealt with anything like that, and God forbid identity theft, you can take like 2 hours out of your day or longer to deal with the situation, and it's really scary that somebody keeps trying to open credit cards as William Tong at Bank of America, and they offer so many different products, right? These are airline cards, by the way. So thank you, Avello, for sponsoring. But you know, it's like the Spirit card, the Allegiant card, the American Airlines card. There are all these cards that somebody's trying to open under my name, and I got to stay on top of it. And imagine if they hit a mother load of information about me that enabled them to get beyond. They haven't been successful yet, but so I get a notice for Bank of America, and I put all the credit freezes on and all of that. But if they can get that extra bit of information, like my social security number or a password, and breach that level of security that's protecting me now, I'm in big trouble. So it affects all of us, every single one of us, and these personal rights are really important to all of us and our families. So with that, happy to take some questions. I have to jump in about 10 minutes, but anybody?
Question as a consumer.
Yeah.
So you talked a list about, being able to learn what somebody has. How do you do that? I mean, I think about all these forms that I filled out, like you said, so get this product. How do I let a consumer explore that?
It's not easy. It's